Auntie Lauren. Hey, Lauren. Good to see you. We have missed you, ma'am. We have missed your beautiful face. Yes, we have. Hi, Lauren. Good to see you. Sorry, Ween baby. I was running behind. And I tried to get in here quickly. But the kiddos had other plans. Hey, Cynthia Boo Jack. Good to see you. Good morning to you. Good afternoon to me. It's afternoon here. I'm doing well. Allergies are trying to make an appearance. So I'm having to had to take some, what is the stuff you squirt up your nose for allergies? I had to take that stuff this morning. Or today. Not, it wasn't morning. It was a while ago. But yeah. Hi. Hey, Miss Morgana Banana. Oh my goodness. Hi, guys. Say hi as you're coming in. Say hey as you're coming in. I'm excited because today, Miss Lori decides, well, she had a motion hearing, it was a motion hearing today. And pollen is high right now, right? Yeah. And don't forget to put your DNA on that thumbs up button. I would appreciate it. You guys, Lori Vallow, she is something else. Hey, Gail. Good to see you. Hello, friends. Lori Vallow is something else. So, she makes her appearance today in court. And I really wasn't even going to stream it. I didn't know what I was going to stream today, actually, because we're not streaming any trials right now. But I was like, I wasn't going to stream the hearing. I actually didn't know how long it was going to be, and it's rather short. But I was like, she starts making some arguments, and I'm like, wow, look at you. Using words like truth of the matter asserted, phrases rather. And look at you stating case law, and look at you making arguments about different things, So I was like, and at one point, the judge is asking questions to try to pull out her reasoning for why she wants certain things. And it almost sounded like he was like teasing, but not teasing. So I just thought it would be cool to watch Lori pretend to be a lawyer, I thought that it would be pretty cool. So that's what we're going to do today. It's going to be rather short, but it's kind of making me itch to want to get into like from the beginning recap of Charles Vallow and Alex Cox, her brother, and all that jazz. Right, Lauren? She has nothing to do, so she's just reading books or whatever. Yeah. Yeah. She's something else, I'll tell you that much. Let's get started on this. Let's get started. I'm excited for you guys to see this if you haven't already seen it.
All right, this is State of Arizona versus Lori Daybell, CR 2021 001704, CR 2022 001242.
Okay, so here she is in her cute little, third grader hairdo. She always wears her hair like that now, and it drives me crazy. It's her little, pull the sides up here, really high little pony. Mm, mm-hmm. And this woman over here beside of her is her, what do they call it? It's not her legal counsel, but it's sort of her advisor, I guess, so to speak. Yes, Kool-Aid lips, Lauren, right? Mm. All aboard the crazy train. She crazy.
Attorney Kay, on behalf of the state, for the record, the next of kin in the 2021 and the victim in the 2022 are appearing virtually. Good morning, Your Honor. Pamela Hicks, Advisory Counsel on behalf of Ms. Daybell, and Robert Abernathy is out of the office today.
Okay. You want to announce?
He's like, you're counseling yourself. Do you want to tell me who you are? Hello?
Lori Daybell, on
Thank you.
behalf of myself.
Lori Daybell, on behalf of myself. She's like, why? You know who I am. Why do I have to tell you who I am? Listen to her. I can't with her. Hold on.
All right.
Daybell. Good morning, Your Honor. Pamela Hicks, Advisory Counsel on behalf of Ms. Daybell, and Robert Abernathy is out of the office today.
Okay. You want to announce?
Lori Daybell, on
Thank you.
behalf of myself.
All right, we have a number of things to get through this morning. The first thing I want to address is there's been multiple media requests.
So he's going to talk first about media requests. And hey, Latanya, good to see you. Latanya says, hey, are you going to rewatch the house fire trial? I haven't started it. I haven't looked at it. So, I mean, I don't know yet. I guess it kind of depends. Oh, hi, Alice. Hi, and welcome. And yes, right? She's using her tiny girl voice to sweeten up the judge. Gag me with a spoon. She's so gross. But she gets a little feisty here in a little bit. Sounding like a real pretend judge or lawyer.
I don't know if there's a representative of the media that can address this, but my question is, if there's a single pool camera, is there some sort of agreement or cooperation between other media outlets to use a single camera?
Your Honor, if I may, Matthew Kelly, I represent Court TV, and our understanding is that, yes, there is a pool arrangement, and Court TV has asked to be the pool for the trials in this matter. I believe that that request is pending with the PIO. Regardless.
Oh, was it good, Latanya? I really haven't seen it. I mean, I haven't really paid much attention to it. I've seen it throughout my news feed on YouTube, but I haven't clicked in to look at it. I know Morgana, I think, was watching it, and probably others in the chat. I just wasn't. What were we doing? We were covering something else when that started. I think the corn rake murder trial thingy majigger. I think we were watching that when the house fire trial started, and so we, didn't get caught up with it. Phone is annoying. Stop it. Kohlberger, yeah. Yeah. Yep. Okay. But I'll have to go back and watch it. And every once in a while, I like to take a poll. When we're kind of in between trials, I like to take a poll and see what, what the folks in the chat want to watch. So, we might do that. I don't know. I did see that Kathy Russin had mentioned that there was a new trial that was going to be starting tomorrow on Wednesday, but I don't know what trial it is. I haven't dug to see what's coming up. So if anybody has any idea of what new trial is going to be popping up tomorrow, let me know. Let me know.
The media that are interested in camera coverage do have a pool arrangement.
Okay. I know that there was, I don't know if it was Court TV or another outlet requested multiple cameras and a still camera. I'm inclined to just allow a single camera. Do you want to speak to that?
Yes, Your Honor. Court TV would prefer to have two of its own cameras. One of its own cameras is perfectly fine. Court TV's equipment is actually smaller than the camera we have here today, and can be operated remotely, so it is much more unobtrusive. Court TV also has, in the past, used the feed from one of the cameras here for the webcasting
Hi,
of
Henny.
hearings for its purposes as well. Court TV will position its camera so that jurors are not in the field of view and would not use any of these cameras that have a view of the jurors.
All right, thank you. Is there anyone else here from the media that wants to be heard? I don't hear any. State want to take a position?
No, Your Honor.
All right, I know the defendant filed an objection. I've read your objection. Do you have anything you want to add to that?
Yeah, Your Honor, I'd just like to add some case law to that. Shepard versus Maxwell, 337 U.S. The United States Supreme Court, Mr. Justice Clark, held that failure of the state judge in murder prosecution to protect defendant from inherently prejudicial publicity, which saturated the community to control disruptive influences in courtroom, deprived the defendant of a fair trial consistent with due process.
Blah, 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 blah. Hey, Margaret. Hi, ma'am. Good to see you. Good to see you.
So that and Arizona versus Cheney, which was the defendant is entitled to fair and impartial trial when publicity pervades court proceedings to the extent that the proceedings were prejudiced to the defendant. So obviously you read my objection, so I just wanted to add those on the record.
Okay.
Thank you.
Your prior attorneys had filed a series of objections to media coverage media being allowed in the courtroom, and I made a prior ruling that was filed back September 4th.
Just a side note, I love this judge's hair. I want my husband to cut his that way, but he will not do it. Actually, he could if he wanted to, but he just flat will not. I mean, he says that it won't lay right, but I beg to differ. Anyway, Alice says if she thinks having no cameras can save her now, she's more delusional than I thought. Girl, we've seen it all, right? Right? I know. Especially considering that whole Dateline episode, which, by the way, did anybody watch? I am super perturbed, okay? So, I did not get to see the Dateline special yet. Okay. So, my husband is like the gatekeeper of all the TV apps, right? And he's the one that sets them up. And he uses like 15 different passwords because kids, they learn one password, then they try to use it for all of it, right? So anyway, um, I haven't got to watch it yet. I couldn't watch it on the night that it came out on Friday because I don't have the NBC Live, whatever. So the next day I was going to watch it on Peacock and forgot all about it because I was busy doing other things. And then Sunday I was going to watch it. And again, Sunday was like a busy day, getting stuff ready for the week, cleaning, laundry, all that stuff. And then yesterday I was going to watch it and forgot to ask my husband what the Peacock password is. So, oh my God, I'm going to have to watch it tonight. I've I watched like part of that Alice, Colby's reaction. Poor kid, man. Whew. Morgana watched it. Margaret watched it. Yeah. Alice seen it. I'm assuming it's worth a watch, right? Kool-Aid Lips 321. That's the password. There you go, Ween Baby. Hold on a minute. I had to get my handy dandy paper towels. My chair is squeaky because my nose is running. Sorry. But yeah. I want to watch it. She gives Keith a run for his money. Like, I can tell just by the little, 2-minute clip I saw. She gives him a run for his money, I think. And I did read that she, bounced around and wouldn't answer his actual questions. Like, she would bounce around to something else. I can tell it's warming up because I've got a little, gnat. They drive me crazy in here. I think the gnats love my overhead light. There's always one little bitty teeny gnat just running around. I think it's been here since last year. It's moved into my office space. Not really. He just knows she's full of it. She's full of a lot of stuff. Ugh. Gross. She's disgusting.
Which was fairly comprehensive. I am inclined to allow one pool camera. I'll issue an order with more detailed findings later today or tomorrow. But essentially, there won't be any media coverage during the jury selection process, and I'll put the reasons for that in the order.
Cuckoo clocks.
So that's, again, I'll issue a more detailed order later today or tomorrow. All right.
Your Honor, there's also the issue of whether Court TV would be allowed to live stream the trial. In other words, broadcast online in real time. Court TV would prefer to do that.
Are you able to,
Oh, and just so you know, pay attention because she's got her wedding ring on. Yeah. She's got her wedding ring on. Not the, obsidian or whatever it was. What kind of stone was it that she ordered for her and Chad? Do you guys remember what the name of that stone was that she ordered? I don't think it was obsidian. It was something else. Should have been obsidian because she's absurd. Oh, Chrissy, hey, I got your message. Malachite. Malachite. That's it. You're right. That's it. But she doesn't have that ring now, so she's made a ring out of something. I can't remember what, like a hairband or a rubber band or tape or something. But she wears it on her left ring finger like it's her. Get out of here, you little gnat! God. Yeah, I heard him talk about the wedding ring, Alice. I did hear him talk about that part. It's just disgusting. Um, but Chrissy, I was going to tell you, I did get your message, and because you couldn't find the channel this morning, weird. That is weird. Sometimes you have to type in because my actual like at handle is Crime Cafe Live. Live, Crime Cafe Live. Um, so that should help. But what I was going to say is I haven't had a chance to reply to your message yet because I wanted to take a minute and like get my like some good information for you for what you were talking about. But you did that from 2 different accounts. Crime Cafe Live. There's a Crime Cafe podcast that pops up. I don't know. I don't know. Okay, we'll get back to it.
Are they able to do a 1 or 2 minute delay?
Certainly, we can certainly do that. I just want to inform Your Honor, however, that when we share the footage with
1 or 2 minute delay is much better than 30 minutes that we had in that other trial. God, that was, I mean, I thought that wasn't too bad, but man, it was torturous most days.
the pool, we can't delay that footage. So your order would need to require that all media receiving the feed delay it by, however long you wish to delay it.
And the camera, the pool camera would be simultaneously distributing that feed to whatever media requests it?
That's correct. We have the capability to distribute to up to 30 or 40 different media outlets, so we have plenty of bandwidth to do so.
All right. Thank you.
Thank you.
All right.
Thank you,
Let's get down
Morgana.
to business on some of the.
Let's get down to brass tacks. Yes, Morgana, thank you, ma'am, again for the reminder. If you guys are popping in and you haven't yet, please make sure to hit that thumbs up button because, see, when you hit that thumbs up button, that helps every little bit. And then it helps people like Chrissy, who typed in my name in the search thing, be able to find me a little easier. Ween Baby said, I have a question. How are you supposed to make Kool-Aid in prison? Do they give you a pitcher? Oh. Well, I would assume, I don't know though, in prison, do they get like cups of water or like bottles of water? You know what I mean? Like, what do they get? Do they get like bottled water or do they get like cups of water? I have no idea. I know that Sarah Boone was ordering like crap tons and tons and tons of those sugar packets. So that kind of made me think, that she was using them like in a thing that have water, the little sink thing on the toilet. Meow. Lori's like, oh, I need some water. I'll just go over here to the portal potty and get me some water.
Your Honor.
Yep.
You want some water too, Chad? I'll get you some water while we're in the portal potty.
I just add that we want to make sure that the camera's not going to be zooming in at any level to get to our notes and the things that are going to be on the table. I also previously what has happened before is that they just have the camera
Quit screaming, Lori. God, I gotta turn this volume down again.
on my face the entire trial. So I think when the judge is speaking, the judge needs to be on the camera. When the state is speaking, they need to be on camera. If we can add that to the order, I think
All
it
right,
would
well,
be
my
good.
draft already includes
You can
that there'll
see-
be no zooming in on count.
Oh, hold on. You can see her right there. You can see it on her left hand. That black, whatever it is. I don't remember now what she's making her wedding ring out of, but there you go. There you go.
The order, I think
All
it
right,
would
well,
be
my
correct.
draft already includes that there'll be
It
no
looks
zooming in
massive.
on
Huge.
council table, anything on council
Hey,
table,
Miss
or anything
King.
being handled, notes or that sort of thing being handled by any of the
Hi.
parties or the attorneys. As far as what they focus on, they'll be limited to focusing on the parties, myself, the witness, depending on the witness. I need to ask the state about that in a second, but they won't be allowed to broadcast any image of any juror. While I'm on that subject, let me ask the state, are you seeking any sort of protective order when a named victim testifies?
Not at this time, Your Honor.
Will you let me know if that changes?
Yes, I will.
Do you have, do you have the names of your designated victim or victim representatives that
Look at her
might be
cute little
testifying?
pink socks and her
Kay
jail
Woodcock
slides.
is a statutory legal victim and will be testifying.
Is that the only one?
At this time, yes.
Okay,
For this trial, I should say.
for this trial, okay. Let me
Right,
ask
queen
this,
baby.
are the parties ready to proceed around March 31st to April 1st?
Yes. Yes, Your Honor.
All right, let me ask the state next. Earlier during these proceedings and past hearings, you indicated you thought the state's case in chief would take 2 weeks. You requested yesterday to screen for 6 weeks.
Your Honor, I did say 2 to 3 weeks.
Okay,
Listen,
But I did say that while we had a defense attorney on and not Ms. Vallow herself. I am familiar.
she's like, I initially said 2 weeks, but now that Lori's defending her own self, I think we're going to need 6. Oh, she's like, I've watched some pro se stuff, and have you seen Daryl Brooks?
Familiar with other pro per trials where generally the timelines are in excess of those with a defense attorney assigned.
Right,
So
Ms.
in order
King.
to ensure that we aren't asking a jury later to stay longer than we pre-screen them, I believe it would be appropriate to screen them for 6 weeks.
so now that you're gearing up for trial and maybe you have a better idea, how long do you think your case in chief would take with a normal amount of cross? I know that's hard to estimate.
And again, I would say
Who's that ween baby?
3 weeks?
that would be at the outset of it.
Okay.
Probably, yeah, 2 to 3 weeks.
Okay. Let me ask advisory council, if we do an questionnaire, would you be assisting Ms. Daybell with your laptop in going through the answers that are received?
Yes, Your Honor. I mean, assuming we do all of that, because a lot of times the courts send us back to our office to go through that. So if we do that here, then yes, of course, she's welcome to use our laptops.
Right. My plan is we can do jury selection in the South Court Tower 5C. I know that the state has requested that the entire trial be held there. We can't do it. We can do jury selection there. I can give you rooms here for your victims and witnesses as need be that are outside this courtroom that we can have them stream in if you want, depending on, I guess, who the witness is or who's back there.
Hey,
And
Cynthia
obviously, Your
Boudreaux.
Honor, I don't know if the public will be attending this or not. This also is a little different in that even in the morning.
I'm sure the public will be in attendance. Yeah. I mean, I don't think that there's going to be as much, let me just say, I don't think that there's going to be near as much hoopla over this as there was the previous trial or Chad Daybell's trial. But, which, that trial was concerning the kids. And this trial is concerning, Charles Vallow and Brandon Boudreaux, I think. Is it Brandon? I think his name is his name. But, yeah. But how are you, Miss Cynthia? How are you doing? I'm glad you're here today, ma'am.
Mornings, the jury is going to be potentially out here while the court is having morning calendar. If there's media out there as well, I'm just trying to protect the integrity of the trial by ensuring that the public, the media, are not interacting with witnesses at any time while they're out there. It's difficult when it's a very small hallway and very limited rooms to put them in. Obviously, I need a room for the victims that's separate from any witnesses.
Well, we have on this floor 6 rooms, 5 or 6 rooms throughout. We have 3 right behind this courtroom, and we can utilize them as need be to ensure that there's no improper contact between media or the public in general and any victims or witnesses. We can also ensure that the jurors don't have contact. If that means we bring them up in a separate elevator and have them assemble somewhere else, we can accomplish that. So my plan will be to do an e-questionnaire, remote questionnaire for the first 200 jurors. That questionnaire, I need to get a final joint pretrial statement with the list of witnesses to include the names of witnesses in that, but I'd like to send out a draft to everyone by the end of this week. Let me bring up my calendar.
Hey, Sherry. Good to see you. Sunny and 65. Nice. It's been pretty here, too. But
We would probably,
so I take, not Claritin. What's the other one? Zyrtec. I take Zyrtec. The kids take Claritin. I take Zyrtec every day or every night. But my allergies have kicked up. Oh, look at that. Member for 6 months. Yay! Woohoo! Whoop, whoop. Whoop, whoop. My allergies have kicked up the last few days because I've spent some time outside. And so today I had to take some of the stuff you squirt up your nose. What is that called? I forget. I wanted to say singular, but that's not it. I forget what it's called. You guys know what I'm talking about, right? Margaret swears by it too. What is it? Starts with an F, I think. Flonase. That's it. Flonase. Yes, yes, yes. Flonase. I was going to say diflucan, but I was like, nah, I think diflucan is for like other issues. But anyway, I knew it had an F in it. Ooh, the judge is spicy. O'Shea Jordan. Where's that at? When did it start, Ween Baby? Give me the details, ma'am. Yeah, the nasal spray, Lauren, is the Flonase is what it's called. But I've been having to use that, Sherry. But she says she's been prepping the flower beds for fresh mulch. It's a beautiful day, sunny and 65. Yes. Right, Morgana? Yeah, I was like, flow, and then I was like, is it diflu? No, diflucan is for something else. Oh, funny. Yeah, don't put that up your nose. But yeah, I've been enjoying the weather.
I send that out to the first 200 jurors around next Thursday, March 20th. Yeah. Oh, I guess they can't send it out. Okay, so we can send out that the 24th to the 27th, meaning it would be cut off on the 27th. The answers to those questionnaires would be emailed to the parties. That would give the parties the 28th, 29th, 30th, and 31st to go through those answers. We would meet on the morning of the 1st, discuss who needs to be let go based on those answers.
That's going to be a difficult
Also, on the
process.
morning of the 1st, a number of walk-in jurors that for
That's going to be a difficult process, I think, getting the jury picked. But I mean, I think it's going to take some time. I think he's going to allow about he says, well, I'll let you listen. Um, that trial started today, Ween Baby. Okay. Well, I'll have to look into that.
whatever reason don't fill out the questionnaire in advance would come in to the jury room, the jury assembly room that morning and fill out the questionnaire. So that morning, we'd also deal with those walk-in answers as best we can. Oh, that's right. I back up. The initial answers for the remote, we're gonna meet on the 31st. Let those people go. Whoever we don't let go will be told to report on the afternoon of the 1st. On the afternoon of the 1st, we'll be dealing with the walk-ins that come in the morning of the 1st. And the people that we haven't let go the afternoon of the 1st, that will be in person voir dire as needed. If we need to, which I anticipate we probably will, we'll do another 200 jurors on the 2nd. And if need be, we have another 100 jurors on the 3rd.
That next set of 200, that wouldn't be a remote question?
They don't
that'd be
have a
regular.
capability to do it remote, so we may have to, what'll happen is on the 1st, all those people, after they give their answers, will be randomized, the list will be re-randomized. As we proceed through the 2nd, those people get added onto the bottom of the list. So as soon as we get 12 jurors that qualify, that everyone's happy with, that don't have issues, plus probably 3 or 4 alternates. So as soon as we get to about 15 or 16, we're pretty much done with jury selection. So we don't have to necessarily question all 200 of those people. We can do panels of 20 or something like that. I anticipate losing quite a large number of people just based on prior media coverage and people already having some sort of opinion about the case. I normally wouldn't include a defendant's name in the e-questionnaire that goes out remotely, but on this case, I'm inclined to, just because that's what we want to know. We want to know if people have heard about the defendant and whether or not they've heard about, or if they've formed an opinion about her or this case prior to that. Does anyone have an issue with that, State?
No, Your Honor, I think that that's a good idea. That's going to be at least one of the initial reasons to strike a lot of jurors.
My only issue with it, Your Honor, is that it could be bad both ways, right? If you put the name in there, if you don't put the name in there. It's been my experience that people will say they haven't heard when they know who that really is, and there's people that will want to be on this jury just for this purpose.
Well,
I mean, she ain't lying. I know a lot of people who would love to be on that jury specifically because it's her. And they want to, like, guilty. You know what I mean?
It's going to be complicated.
All the research indicates that these e-questionnaires, people are more likely to give honest, candid answers than if they're in a group of people and they feel sort of that peer pressure of what's a good answer and what's a bad answer. Your name's going to come up sooner or later, so I would prefer to just get it out in front of the potential jurors to begin with. My e-questionnaire is going to be fairly basic.
Kel.
It's going to focus on qualifications, the charges, the witnesses, and then obviously whether they have an opinion about you or this case. For the people that make it past that level, we'll question them more thoroughly in person.
And like you were saying, as far as group kind of voir dire, in my experience, we went through 1,900 jurors in my last trial, so it would be good to do individual voir dire if we can, than group voir dire, because they learn things just in the voir dire and it disqualifies a lot of jurors.
I'm not opposed to that, but that's going to be sort of a day of play it by ear sort of situation, whether we do small panels or just go a single person. If we go single person, our jury selection could extend into the next week. But if we're able to seat a jury, I would expect opening statements on April 7th, somewhere around there. Does the state indicated, I have it, there was just one day in April that you wanted
Steph.
to go a half day?
Correct, Your Honor,
Hey.
the 24th.
All right. When can you file some sort of pretrial statement that sets forth all your potential witnesses and a statement of the facts?
Probably by Thursday.
All right. Does the state anticipate any presentation of autopsy photos or crime scene photos? In other words, I'm trying to gauge, I would usually put in a question about jurors may be required to view evidence that shows wounds or that sort of thing. Is there anyone that's unwilling to look at this type of evidence?
Yes, Your Honor, we will have both, obviously, with self-defense trajectory, and those injuries are very relevant.
Okay, so I will include a question about that type of evidence. Sometimes jurors don't want to look at that type of evidence, so. All right, any questions or concerns about our jury selection, the proposed trial dates from the state?
No, Your Honor.
Just so I have it clear, Your Honor, we're going to start on the 31st with jury selection, is that
We'll
correct?
be meeting on the 31st,
Okay.
and then actual dealing with in-person jurors on the 1st, 2nd, 3rd.
Okay.
Let me ask advisory council, are there any dates that advisory council would need to be dark?
I am fine for April. I didn't hear back from Robert. I would think.
Please
he'll be
let us
fine.
know, because in that e-questionnaire, I'm going to put in a proposed schedule. I don't know that I'm going to screen for a full 6 weeks based on the state's anticipated presentation, maybe 5 weeks. So let us know the schedule into the first week or two of May.
As soon as I get an answer from him, I'll email your judicial assistant.
All right.
And one more time, Your Honor, so the remote question is going out on March 24th.
all answers have to be back by the 27th, so we will get them on the 27th, or,
You'll either get them late the 27th or first thing the 28th.
okay,
Oh, okay.
okay.
You should get them some point on the 27th.
Just so we can plan, because it sounds like we'll just go out to Estrella and go through these.
Yeah, they're closing it at like 8 AM on the 27th.
You'll have to have a internet connection.
Yeah,
out
we
there.
can use
Okay.
our laptops out there,
Okay.
because you want to be ready to discuss everything on March 31st.
Yeah, and
That's
if the parties have an obvious, you know, there's some jurors that are gonna be obvious that need to be let go. If you're ready for that, that's always helpful. I know it's a little bit more difficult with pro per defendant in consulting like that. All right, let me get to,
So we'll come out on Friday. And go through the questionnaire.
We don't get any questions on that.
all right, the defendant had filed two separate motions for specific discovery. The first dealt with communication between the assigned deputy county attorney and law enforcement agencies. I've read and the second one was, well, let's deal with the first one. I've read the response from the state. Basically, your response is you have disclosed all those communications. There are no other communications.
Correct, Your Honor.
All right. So let me ask the defendant,
Yeah, we received 6 email communications, and they were in a short time frame, not the full time frame. And it seems to me that in the last email ends in kind of a question that was probably answered, and then there's like no more communication. So it doesn't make sense that there's no more. We asked for all of them if they could be provided to us. We don't understand why they're not being provided to us, and what the state is possibly hiding at this point, and they can't just turn it over so that we can go through them. It's been, long over a month since we filed that motion, so we would just like them to please turn over whatever they have left.
This
All
is
right, and-
where
I'll ask,
it was this part. I was like, yeah, I'm not going to bother streaming this today. And then she starts this argument, and I was like, oh, look at her go. You're cute, Steph. You're cute. Oh gosh, it's good to have you join in today, ma'am.
the deputy county attorney, I imagine some communications are by phone, so in other words, we're not captured.
Correct, Your Honor.
All right. Based on the states of Vallow, I don't know, I can't tell them to turn over something they say they don't have, so. I'll find that the state, based on their Vallow and officers of the court, have complied with the request. The second one is a little more, I wanted to get clarification on. That was defendant's request for video interviews, but it seemed like based on the state's response that there was some confusion about what was a interview recorded in an interrogation room situation versus a body cam. Did the state's response provide clarification to you?
No. So the body cams were turned over, and they're in like 12-minute increments. There's like 4 different body cams. This was a full 2-hour video that was released by Gilbert Police to the public, and it's online. So I would like that video of the interrogation room, the full 2-hour one, to be turned over to the defense.
All right, so do you know what that is?
Your Honor, based upon the defendant's reply, she's requesting a video interview from the 31st. Those are on body cam and were turned over to the defense. We have requested everything from, I think that one was from actually the Gilbert Police Department. A lot of these overlap. So I am not sure what the defendant is.
Who was the person being interviewed, and you said the 2 hour interrogation.
This is a little strange to me because I hate to say this. God knows I hate to say this, but Lori is right in this. So the defense said that they've got body cam footage, which they do, but there is the longer, like, interrogation room video. We've watched it before here. I'm pretty sure. I know I've seen it multiple times. But yeah, I'm not so sure. I don't remember Alex Cox's though, but I do remember Lori and Tylee. Do you guys remember the videos where they're sitting, like Lori comes in and sits down and she's sitting in a chair, and then there's another one of Tylee, and you see Tylee like sitting cross-legged on a couch with there's like a teddy bear on the couch or something, and they're interviewing her. Those are the videos that Lori's talking about. And so, yeah, I don't know why the defense, I don't know, is acting like they don't know what that is. It's all over the internet.
Interrogation that Gilbert released.
So it's myself and my daughter, Tylee Ryan, and Melanie Gibb.
And is that in an interrogation type room?
Yeah, it was at the Gilbert Police Station, and I didn't realize we were being filmed that whole time. I didn't know we were being filmed, but we were being filmed in that room.
And are you familiar with a video in a room?
Yes, that's what we have disclosed, is an interview of, it is
And you're saying you don't have it?
defendant, her daughter, and another.
And you're saying you haven't gotten that?
They have given 4 about 12-minute body cam videos of the policemen's body cams that were in the room with us, and they go in and out of the room at different times. So there's different body cams. They're all mixed up. It's not the full entire one, and the full entire, my understanding is that the full entire 2-hour interrogation room video from the ceiling is available online, but I don't have it in Discovery.
That's what I'm trying to clarify. So did the state disclose not a body cam, but an interrogation from up in the corner of a room vantage point?
I mean, we disclosed a lot. Let me see if I can find out. We did. Yes, my paralegal is present here as well, and she has advised that we did. Your Honor, we disclosed over.
Can your
Where is
paralegal
it?
provide a Bates number or something so that maybe the defense just has overlooked it?
Let's see if we can find the actual
Maybe the discovery notice.
discovery letter.
Okay.
It's funny because here in a second, the judge will say something about, oh, I can't remember if it was this part or the other part. Anyway, the judge says whatever, and then Lori's like, like, like she knew she got that win, you know. Steph, I would love to. I need to get the password so I can stinking figure out how to watch it on my password to Peacock is what I'm talking about, because Dale has it and I don't know what the password is, so I'll have to get logged in so I can watch it. And what is this with Lori's like outfit? Like, it's not an outfit. I know it's her orange gel attire, right? But it looks like she has on an orange sports bra or tank top. And then she's off the shouldering her gel top. Like, what is she doing? Fashionista. So the paralegal is looking for the bait stamp on that surveil or not surveillance, the interrogation room video. And trying, right, Lauren? Gross. She's so gross. Did you wean, baby? God. And her little third grader sides up on a pony and a ponytail on top of her head.
Your Honor, all we do have is the 4 body cam. We can ask again and see if they have a overall.
Are you getting this? Have you seen this, or someone told you that there's this video?
My mitigator showed me part of that video, yes, with my previous team. That's how I know about it, otherwise I wouldn't know about it. She said, do you know this is online? I didn't have any idea.
And you're sure it's the Gilbert PD on that date?
Correct.
All right, I'll ask the state to follow up with Gilbert on that.
We will, Your Honor.
There, if that is out there, obviously it should have been disclosed.
Listen. Did you hear? Sorry.
All right, remind me
said
to follow up on that.
Listen, you hear Lori. He says, obviously, if the state has that, that needs to be disclosed or should have been disclosed or whatever. And Lori goes, Listen.
Next time
Listen,
with Gilbert on that.
We will, Your Honor.
There, if that is out there, obviously it should have been disclosed. All right, remind me to
Did you
follow
hear it?
up on that next time we are together. Next, I have a motion limine, 2 motions in limine, one regarding Alex Cox statements and one regarding Tylee Ryan's statements.
Why do all ugly people have good hair? I don't know. I mean, Lori used to have
All
good
right,
hair. She
so-
don't no more.
Let me ask the defendant, generally any hearsay is defined as any out-of-court statement offered for the truth of the matter asserted. The state is referencing what are definitely out-of-court statements. Obviously, there's
Now, this is another good section where Lori argues her whole face off concerning what he's getting ready to bring up now. And this is her next segment of pretending to be a lawyer, right? This is where she brings up the phrases that we hear all the time in court: truth of the matter asserted, court law, like all the legal jargon. I'm going to get that gnat yet. You watch and see. I've got a fly swatter in here somewhere. I don't know where it's at. Jolie had it a while ago. But anyway, yeah. So I can't wait for you guys to hear this. In the meantime, I'm going to run to the bathroom really quickly. So I will be right back. But listen.
some exceptions to the hearsay rule, and there are other things that are characterized as non-hearsay. So how do you think, let's first talk about Alex Cox. How do you think the statements fit into your, either one of those exceptions or non-hearsay?
I feel like the state is blanketing that whole thing, and obviously it's like a case-by-case basis, right, on these statements. So there is the police interview of Alex Cox that I do not think falls under hearsay.
Why not?
Why does it not fall under hearsay?
Yeah.
Because we're not using it for the truth of the matter asserted. We're using it in corroboration of the circumstances. Everyone came in and told their same story that corroborates different facts in there, not for the whole truth of the matter.
Aren't you arguing that what he said was true?
I can't say whether another person says that it's true or not, but I'm saying what he said, and what my daughter said and what I said in those 3 police interviews determined what the police said, how the police acted, what they did after that, their next steps, how they treated the entire case like it was self-defense. All of those are relevant to the defense that it was self-defense. So, yes, I think they're for that purpose. But I also think that Alex's statements also have a lot of the exceptions apply. 803, 804, there's a lot of exceptions that also apply to some of his statements and not all of his statements.
Such as what? Which statements do you think they apply
So
to?
Specifically his statements made on body cam to police in the driveway, specifically his.
I don't know what the statements are, so that's what I'm asking. What specific statements do you think are allowed to come in under the rules of evidence?
I think under 8031, the present sense impression is his statements made to police officers at the house.
A present sense impression is where you're actually observing something and you're talking about it as you see it happen. So, isn't he saying, again, I don't know what the statements are, but is he saying what happened prior? Or is he saying
Yes,
something that
prior.
he's, okay,
Correct,
so it's not a
prior.
present sense impression.
Okay.
What else?
Then I think it falls under 8032, excited utterance. He was under the stress of the whole situation when he made those statements.
What was his demeanor when he made those statements?
Upset.
What's the specific statement?
I shot my brother-in-law in self-defense. I got hit in the head with a bat. There was an altercation. I don't know what all the statements are, but
How long after the incident did he make these statements?
immediately after, as far as I know.
Well, immediately to some people means 2 seconds, to other people it means
Okay, I'm back.
30
I
minutes.
gotta stop this and rewind it and listen to that again because I almost thought the first time that I watched this today that I heard the judge kind of like make like under his breath laugh, like a small one, just a couple seconds ago. And I want to rewatch this and kill it. Sorry, I was reading Cynthia's comment. She says she killed her children. Shut up, you know what? And so the word killed came out of my mouth when it wasn't supposed to, but just goes to show my mouth says what my brain sees. Hearing her call Tylee her daughter makes me cringe. Me too, ween baby. I was literally in the bathroom watching this on my phone, and when she said that, I said, you ain't got no right to call her your daughter. Just saying. But anyway, so let me rewind this back but did you hear, because when I first started the stream, my brain is all over the place. Just hearing her make these arguments is like, I cannot wait for this trial. Cannot wait for this trial. We'll talk more about that here in a minute, but she's a lot. I mentioned earlier that the judge was asking her questions when she was making this argument, almost like he was teasing her without teasing her, because he's like, okay, I see that you're making these arguments, but you have to give me reason why. And she's not being super specific, you know. But I want to go back. I want to rewind it a few seconds and see what you guys think if you actually hear sort of a under his breath laugh. Okay, I think that's probably too far, but we'll go with it.
Is his statements made to police officers at the house.
A present sense impression is where you're actually observing something and you're talking about it as you see it happen. So, isn't he saying, again, I don't know what the statements are, but is he saying what happened prior? Or is he saying
Yes,
something that
prior.
he's, okay,
Correct,
so it's not a
prior.
present sense impression.
Okay.
What else?
Then I think it falls under 803.2, excited utterance. He was under the stress of the whole situation when he made those statements.
Right there.
What was his demeanor when he made those statements?
Because you can kind of hear, it sounds like more, now that I hear it back again, it sounds more like a sigh. But when he says that very last sentence, it almost sounds like he's smiling when he says the sentence. You know what I'm saying? So I wish that we could have seen his face when he says these words. But I feel like it's like yeah. Power's out in the building. Oh no, Margaret. Heading home. Okay. Why is the power out? Just some random thing, or is it weather related, or... Hey, Patricia. Good to see you, ma'am. Good to see you. Good to see you. Okay. I'm going to rewind it back just a few more seconds. One more time. You know I'm a serial rewinder. Be kind and rewind.
Okay.
What else?
Then I think it falls under 803.2, excited utterance. He was under the stress of the whole situation when he made those statements.
What was his demeanor when he made those statements?
Upset.
What's the specific statement?
I shot my brother-in-law in self-defense. I got hit in the head with a bat. There was an altercation. I don't know what all the statements are, but
How long after the incident did he make these statements?
immediately after, as far as I know.
Well, immediately to some people means 2 seconds, to other people it means 30 minutes. Tell me what immediately means to you.
As soon as the police arrived.
I don't know did they arrive 30 minutes after?
This back
the
and
incident?
forth with him and her
10?
cracks me up because he's like, no, I need. This is another part of the teasing thing. Like, he's like, you're not giving me what I need. And it's grating on my nerves. I missed you too, Patricia. I wanted to go live yesterday, but after kiddo's virtual learning day, I was like, blah, blah, blah. And then I thought about doing a nighttime, like a later evening stream, but it didn't happen. So I was like, I'll just wait. Till today. I hope you had a great weekend. And I hope work behaves today too.
Minutes, an hour?
I was not there. I do not know what time they arrived.
All right. Let me, so you're asserting excited utterance, some of these statements come in. What else?
803.3, the mental, emotional, and physical condition, because it shows his state of mind, which was scared at the time.
Any others?
Yes. 803.5b,
And you know what's really sad? She's talking about Alex Cox here, her brother, who's the one that actually shot and killed Charles Vallow. So she's not on charge for the murder. She's on trial, I think, for conspiracy to commit murder. But anyway, in my opinion, he shot Charles because Lori wanted him to. And it is well known that her brother Alex Cox would do, and did anything she wanted him to do. So, um, yeah, I think it was all planned out. And the plan was for her and Tylee to leave so that she wouldn't be, in any kind of trouble, so to speak. But the sad thing is just strangely enough, and I'm never going to believe, because Alex Cox, her brother, dies. Okay? He dies from, apparently, they said it was natural causes or something, but I will never buy that. I will never believe that. I think he either, and this is off topic, kind of, not really, but kind of, I think he either offed himself or he, hey Tammy, good to see you. Hey, hey. I think he either offed himself or he, Chad and Lori collectively decided that now that Alex has done our bidding, we don't need anything more out of him. Um, you know, we'll just get rid of him too now. One or the other, but I don't think it was from natural causes. Even though his autopsy states otherwise. I don't believe that. Okay, we'll get back to it.
Recorded recollection. I know that in the state's reply to my response, they did not think that 805 applied because A, B, and C, but I did not see an and after A, so my assumption was that B and C, since there's an and after B, were what needed to be put together. So B was made or adopted by this witness when the matter was fresh in the witness's memory and accurately reflects the witness's knowledge. So I felt like 803B5B, the recorded recollection of his police interview and the body cam footage, applies under that exception.
All right. Generally, 8035 is a recorded recollection, meaning it's something they wrote down, or maybe they recorded their voice saying something. Let me ask the state
Yeah,
to
her
respond.
talk
We're
is
just
something
talking about
else.
the Alex Cox statements.
Your Honor,
Maybe I should start with, does the state intend on introducing any statements from Alex Cox?
Your Honor, I haven't decided if we will at this point. I can say with 100% certainty, we will not be admitting his interview by police that was done at after 10 o'clock in the morning. We don't,
Are you referencing what time he was interviewed versus the time of the incident?
let me say it this way. So the state has laid out in its motion the timeline. So that is actually in our motion. We show that when
8:30 a.m.
is when
roughly.
the 911 call was made. So we have soon after that, the police arrived and there's body cam video from that interview. Then Alex Cox is later brought to the police station and there is a in-depth interview with detectives at a little after 10 o'clock in the morning.
Mm-hmm.
So you may or may not be attempting to introduce statements at or around the time that the police responded?
Correct, Your Honor. If we do, those would be brought in as co-conspirator statements against a party interest. So obviously the state can bring in statements that are hearsay against a party.
Right. But I guess, is the state intending on introducing any statements of Tylee?
No, Your Honor. Tylee made no statements at the scene other than giving her general biographical information on body cam. Her entire statements were made at the police station again after 10 in the morning.
Yeah.
All right. So on your response as it relates to Tylee, you say, again, present sense impression. I don't think it's a present sense impression. You also argue excited utterance. What else?
8033, which is mental, emotional, and physical condition, with the same thing, her state of mind, then being scared. And also 8043, statement against interest. They use that statement in the indictment where Tylee says that Charles says, if you hit me with that bat, you're going to jail. That's the part where she's nervous in her interview, saying she's scared to tell the police that she's the one that brought in the bat. So state of mind and the statement against interest both apply to Tylee's
All right.
police interview.
I can't stand letting her, I cannot stand hearing her say her name.
All
Right, Miss
anything
King?
else? Does the
Me
state want to be
either.
heard further on that?
Your Honor, the
Me either, Miss King. Now, I know that they said that from whatever, I think he died from something heart related. And they said that there was no like toxins or anything that was found in his system, but I don't believe that. I really do not believe that. I don't. I'll never believe that.
The only further thing I think that the state will bring in is that obviously the defendant has been found guilty of killing both.
Because, see, at this point that he dies, okay, you've got, well, I'll tell you a few reasons, okay? You've got Charles Vallow is now dead, which is Lori's ex-husband. You've got JJ and Tylee, who are both now deceased. God rest their little sweet, precious souls. An attempt was made on Brandon Boudreaux for the money. That failed, though. Tammy Daybell is now out of the picture. So everybody that could have hindered their lovelorn, romantic Hawaiian love story affair is now out of the way, and they have no other need for Alex. No other need. He's done everything that they needed him to do. And so now he's, they don't need him. So let's just get rid of him now. Boop. That's what I think. That's what I think. There was something else I was going to say about that, though. Oh, and another thing that makes me think that he didn't die of natural causes is, do you guys remember that prayer that we heard? We've listened to it here on the channel. I want to go through all this stuff again before the trial so we can get a refresh on it. But do you remember there was a prayer that we heard that was recorded that Chad spoke over Alex Cox? And him and Lori were both crying, and you could hear Alex crying. And it was a very peculiar, like, almost made you think last rites kind of like prayer. You know what I mean? It was very, very strange. So, those are just my thoughts, but put a 1 in the chat if you guys are interested in doing a refresher course on this whole situation before the trial starts. We might have to do that. Put a 1 in the chat if that's something you would like to do.
Tylee, other individuals, but in this case, the defendant cannot benefit from killing a witness and then later tried to bring in their statements for their benefit.
That
So,
was not my phone
in
making that
addition
noise.
to none of her
just so you know.
statements being admissible under the rules of evidence, as any of the exceptions that the defendant has done, we also believe that it would be improper for her to be allowed to bring them in under that theory.
Hey,
In
Brenda.
other words,
Good
there's
to
been
see
a judicial finding that the reason Tylee's unavailable as a witness is because of the defendant's actions.
Correct, Your Honor. There has been a jury trial and she has been convicted of that.
All right. All right, the court is, on a preliminary basis, precluding references to Tylee Ryan's statements, any statement made by Tylee Ryan. If there's some reason where a door might be open to any of those statements coming in, the defendant's requested to make a request outside the presence of the jury regarding that, and we'll deal with that outside the presence of the jury. On Alex Cox, I think that's probably going to be more of a statement by statement basis, but I'm skeptical of any statements coming in hours after the initial police response. I think we'll deal with what statements may or may not come in when the police first arrived on scene and or the 911 at the time that they're attempted to be introduced. All right, I also received yesterday state's notice of disclosure and request for disclosure. Did you get a copy of that?
No,
You haven't seen that yet?
no.
I'm sorry, the
State's notice of disclosure and request for disclosure. I didn't realize, it was actually filed in January, so you should have seen that. I misspoke when I said I got it yesterday. It was filed January 16th. Have you seen that?
I'm looking it up.
What are we?
Dates
I
disclosure.
think that the court may have ruled on that one, Your Honor.
Well, I don't think I ruled on, at the very end, you're requesting, she submit to fingerprints, palm print, footprint.
He kept, egging her like, did you see that? Did you see that? Did you see that? And she's like, I'm looking, Your Honor.
Oh, that's, okay.
I like him. He's very, no muss, no fuss, no coconuts. You know what I'm saying? He's very, I know that was not the right phrase that I just said, but he's like a no mess around. He's like, I love those kind of judges. I do not like Judge John judges, like the old judge from Coburger, the older judge, or the previous judge from Coburger. I can't stand that wishy-washy. You can be wishy-washy if you're, I don't know, anything else but a judge. A judge cannot be wishy-washy. No.
I think that was fired, yes, significantly. So that would be to tie her to any of her.
Is that for other conviction
Correct,
purposes?
yes.
All right. And when did you want to do that?
Right, Lauren? Yes.
If we are going to be here on the 18th, we can take them then.
I don't know that we need to be here on the 18th.
And obviously, I was unaware we were going to set this because we set it
Right.
just recently, so. I don't know if we can keep that on just to take that.
Okay, what about the state, you requested copies of any recorded statements made during interviews conducted outside of your presence? Is there any of those, were there any interviews conducted by you or your team? Of
So
any,
far?
were there any interviews conducted of any witnesses out by you or your team that you're aware of?
So far, not that I'm aware of.
All right.
Somebody needs to tell her to pull her shirt up onto her shoulder and act like she's got some sense. You're not at the beach, ma'am.
Do you
Good
plan on
grief.
calling any experts to testify?
We do plan on calling one expert.
Who's that? Has it been disclosed to the state?
We are, yes, we're working on that today
Right,
as an
Sherry?
addendum to,
I don't like wishy-washy judges. I personally myself am very wishy-washy. I'm one of the most wishy-washiest people on the planet. Self-aware. I'm very aware that I am very wishy-washy. But I do not like wishy-washy judges. No, I don't like wishy-washy judges. Nope, 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 nope.
to the
Who's that?
witness list that, Lonnie Dworkin.
All right. That's your investigator?
No, my investigator, Jeff White.
Oh.
That's the expert.
What kind of expert is Lonnie Dworkin?
Phone and digital.
I think I remember his name. Are you aware of that?
No, Your Honor.
All right, expert reports and disclosures are due 30 days before trial generally under the rules, so if you're planning on using that witness, you need to get that disclosed right away, and I may have to take that up.
Okay, Sherry says me too. That drives my husband crazy. So here's the thing. I'll tell you how wishy-washy I am. Hey, David. Good to see you, buddy. Hello. Here's me being wishy-washy. So a couple nights ago, he made like steak fajitas for dinner. They were delicious, by the way. But anyway, he made steak fajitas. Or the like fajita innards, right? Like the bell peppers and onions and the seasonings and the meat and all that. Well, instead of eating them like on a tortilla, I have the little round like nacho chips, and I just wanted to like, he had plates set out, right? And he had some of the steak on a plate. And he's like, you can have that plate. And he said, I'm getting one out of the dishwasher. And I was like, oh, no, that's okay. You can have this plate. And because I'm going to just eat mine in a bowl. And he's like, okay, okay. So make the kiddos plate, you know, give it to them, her. And then I proceed to pick up the plate with a steak on it and put some of the peppers and onions and the sour cream and chips and all that on the plate. And I go sit down and I start eating. And then he comes back into the room from wherever he was at. And he just looks at me. And I'm like, what? What are you looking at me like that for? And he's like, what happened to you wanting to use a bowl? And I look down and I'm eating off the plate. I was like, oh, I forgot. So he had to go back into the dishwasher to get the plate again. Anyway, I'm very wishy-washy. But I will say I didn't intentionally grab the plate instead of a bowl. I just forgot that I said I was going to use a bowl and grab the plate instead. I don't know. Ms. King says, I agree. John Judge seems nice, but I do not like him as a judge. No. And I feel like he almost seemed very nervous. Like he was nervous. Like he didn't want to upset anybody or make anybody mad or do something out of the way that could cause an issue later, you know. And I'm like, don't. I don't like it. I don't, you know. That just gives me the vibe of he didn't seem very confident, you know. I don't know. David said crazy pants is in court looking like a dime store hussy. Right, that's what I said. She's got her shirt hanging off the shoulder. you know, with her hair pulled these two, like, you know how when you, back in the day when you used to go whoop and make a ponytail, right? Just this part, like little bitty ponytail popped up on top of her head. And that shirt off the shoulder. She looks like she's going to the beach.
Depending on what the state's position is. But
Your
at this
Honor,
point,
that-
it's technically late.
May be another reason to be here on the 18th. Obviously, if that's disclosed this week, we can potentially address that issue on the 18th.
All right. Let me ask the defendant, do you have a position on the taking of prints and photographs, generally identification type
Oh, look, she did pull it up on her
things
shoulder
are
now,
permitted
partially.
over any defendant objections? So do you have a record you want to make on that?
Not really.
All right, I don't see any
For
reason
what
why,
purpose? I don't understand.
in the event that you're convicted, it may be used to prove other convictions.
Here goes another bit of an argument that she's going to have next.
That reminds me, is the state planning on proceeding in the second trial regardless of what happens in the first trial?
I believe so, yes, Your Honor.
And how much time would you need between the conclusion of the first trial and the start of the second trial?
Your Honor, I would say at least 30 days, since we do need to actually subpoena out-of-state witnesses for the second trial.
I'm wondering if it wouldn't benefit everyone to go ahead and set that
Listen
provisional-
to this. Listen to this.
second trial date now.
That's fine, Your Honor.
And just so you're aware, the second trial they're talking about is the attempted murder of Brandon Boudreaux, her niece's ex-husband. I think they're divorced, but her niece's ex-husband. If you guys remember him on the stand during the other trials, he was the one that was shot at and they missed him, and he said it was somebody had shot out of the back of a Jeep or something, and he said the Jeep looked just like the one Tylee had. So anyway, yeah. But I think that's the second trial that they're talking about. So maybe she's using the portal potty and meeting Chad after this hearing. Oh, I know, Miss King, right? Blech. So funny. Gross. Ugh. Brandon Boudreaux. Yep. Yep. Thank goodness he lived.
May 11th is still my last day.
Is that second trial,
Right.
how long do you think it would take the state to
Probably
present?
about 3 weeks as well.
Similar?
I'm gonna- Your Honor, I'd like to remind the court that the last day is May 11th.
Well, I'll probably exclude some time based on the fact that you can't do two trials at once.
The state could.
Okay, so May 11th, I think when she says is the last day, May 11th is like the deadline for her right to the speedy trial, you know? So she's going to argue that, you know, the whole right to the speedy trial issue, she didn't waive that right, blah, blah, blah. But he's like, well, we can't have two trials at once because if he's expecting opening statements is not going to start till that first week, somewhere in April, probably, he said, the 7th of April, and the state is thinking that it's going to last 6 weeks, you know? Anyway, and she's going to try to use that to meh.
Could combine.
Two trial.
The last day is May 11th.
Let me rewind it back so we don't miss that part again. Gross, Morgana.
Your Honor, I'd like to remind the court that the last day is May 11th.
Well, I'll probably exclude some time based on the fact that you can't do two trials at once.
The state could combine the trials and do two trials at once, but they don't want to do two trials at once, so it really violates my speedy trial rights if they do not give me a speedy trial by May 11th for both cases. Not to mention that they did combine all the discovery into one case. They didn't give me two different separate discoveries for two different cases, which would be much more convenient considering the voluminous amount of discovery that they piled onto us.
Does the state want to do combine both cases?
Your Honor, if the court gave us a little time to work it out and the defendant wants to join them, I mean, obviously,
I don't know that,
with a normal defense attorney, and I don't mean that in any way, normally they would be severed.
because you
Due
don't
to-
want one jury to know about the other
Correct.
two separate charges and have a harmful rub-off effect of the evidence in one case affecting the evidence in another case.
Correct, Your Honor. That's why they were filed separately. But if the defendant wants them together, the state would have to request this be pushed back slightly so that we could then get all the witnesses for that trial together, since they were not subpoenaed for this trial. But if that's what the defendant wants to join them, and she understands that prejudice and that she's then going to be waiving that prejudice with that, then the state is certainly willing to do that. But we would then have to request to have that trial, or this trial date moved back to allow us to get the other witnesses lined up.
That's not what I was saying, it's to combine them. I'm just saying, give me my second trial by May 11th. So
Right.
the court can figure that out.
All right, well, I'm going to waive some time on that second trial over the defendant's objection. Primarily, again, the defendant can't try both cases at the same time. Secondly, I'm not sure how much actual prejudice there is with a time violation in the sense that you wouldn't be released from custody anyway. And thirdly, the rule for time violations under Rule 8, I think it's 8.6 is that any violation should be a dismissal without prejudice unless there's an actual prejudice shown, in which case the state could just refile the charge. Regardless, I think some time is warranted to be excluded because primarily you can't try two cases at once. What if we set a start date for May 12th? I realize that's could potentially be a quick turnaround, but again, I don't think this case is going to take 6 weeks.
Your Honor,
We can adjust that as necessary.
I, again, am going to ask for a longer time. I believe this will go through the beginning of May, and to have the state try to get those witnesses lined up and subpoenaed while in trial, I don't believe is.
Well, push it out any further, the parties need to be aware that I won't be trying the case. I don't think I would be anyway. I'm rotating at the end of June. And given some of the trainings I have to attend in June, I don't think we could get it done.
Well, both parties could send out subpoenas now for that second date for May 12th, correct?
Well, that's assuming we're done by about May 1st, probably, in this case, the first case.
And then, Your Honor, I did indicate that the state needs to be dark in May, the 21st, 22nd, and 23rd. You said 21, 22, 23? Correct.
Of May.
And I would need to be dark the 19th, 20th, and 21st as well, so.
So given that we would be dark that entire week anyways, it really doesn't make a whole lot of sense to.
All right, sorry to interrupt. Let me speak with the criminal presiding judge about scheduling the second trial. We can discuss it on the 18th. Let's keep the 18th, but let's move it to later in the morning. Actually, let's move it up. All we're going to do is discuss a couple matters, and then there's no reason for the fingerprinting and stuff to be broadcast or on video, so I'll prohibit that from being recorded or otherwise broadcast. So have your person here. Let's do that at 8:15 a.m. on March 18th. And then we'll also discuss whether the defense is disclosing Lonnie Dworkin as a witness and whether or not he has a report, expert report prepared and disclosed at that time. I will have the questionnaire for you by then, so you can review it. Anything else we need to discuss that I've forgotten about from the state's perspective?
Your Honor, I showed two other motions that the defense filed that I did not see rulings on by the court. They were both motions to dismiss. One of them only related to the 2022 case, I think. No, I'm sorry. Both of them related to both.
What's the filing date?
January 14th for one of them. Was an 8.2 speedy trial one. And February 4th, which was an extradition rule 8.3.
Of February 4th? Okay, so the motion to dismiss CR 2022-001242 for lack of speedy trial, I ruled on January 24th.
Okay.
That minute entry was filed January 24th, and then the motion, was that the motion to dismiss CR 2021 and 001704 and the other for violation of Speedy Trial Act?
Correct.
That was ruled on February 25th, so last week,
Okay.
a week ago. Anything else from the state?
No, Your Honor.
Anything else from the defendant?
Yes, Your Honor, I have one kind of housekeeping matter that I wanted to ask you about. I know that MCSO has some security restraints, the things that I have to wear during trial, and
I meant to
I wanted to ask about that as far as, am I going to be able to stand at the podium to talk to witnesses, to question my witnesses and to cross-examine? Or am I going to be able to move about with the leg thing and the shock vest and all that?
You can, you're going to stick to your table and you can go to the podium. Okay? When you're giving your opening statement and closing argument, you'll stay by the podium.
Okay.
And if you need to hand a witness an exhibit, your advisory council will do that.
Okay. Or my paralegal can do
Or
that
your,
too. or
well,
whatever.
is your paralegal going to be present here designated as your, I guess they can be present. I'd prefer advisory council to be the one
Her
that
paralegal.
approaches witnesses
My
if you need to hand
paralegal.
an exhibit or something like that.
Okay, so I'm going to be standing there, and if she's sitting here, she's going to come get something from me and go walk it over to the witness and then come back?
Correct.
Just the logistics of it? Just
Yeah,
the-
and there'll be a table or a cart here that'll have all the exhibits on it within reach of the podium, so.
Okay.
Anything else?
Your Honor, do you use case lines for exhibits?
No.
So she was talking about whether she would be able to move around the courtroom. And when she said that, it made me think, oh my God. Which, I mean, I knew that this was going to happen, but I didn't really think about it hard until now. You guys, she will be doing cross examination on all of those people. I mean, I know we knew that. I know that we knew that. But I'm thinking Kay Woodcock, Charles' sister, anybody else. I don't even know off the top of my head who all would be witnesses, but I mean, can you imagine? I wonder if Kay would be able to like keep it. I mean, I'm assuming Kay would be a witness, right? I don't know. But I can't imagine her cross-examining any of the people that are like personal to the case, family, friends, who have, you know, that kind of thing. You know. They can't question Tylee because Tylee was there. They can't question her because they killed her. You can't talk to Alex. He's the one that did it for her. He should be on the stand. But you can't talk to him because, in my opinion, well, we know he's dead too, but in my opinion, he, like I said earlier, he either did it himself or they did it to him. So, oh, right, Ween Baby. Ween Baby said, I wish Alex was still alive so he could give me all the tea. I still think there are secrets. Oh, I bet there are secrets. Yeah. Yeah. Yep. Wonder will they be calling Colby Ryan up on the stand? Wonder would they have a need to do that? It would be popcorn time, right? Oh my gosh. I feel so bad for Colby Ryan. Oh my goodness. I feel horrible for him that he has to go through all of this. You know? Very, 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 very sad. So. Me too, Ween Baby. Me too. Need to watch his reaction. My heart breaks for Colby. And you know, he seems to be doing so well. Married, got a little family, and, you know, doing some big things on the interwebs, and I'm happy for him. So, I don't know, you guys. I don't know. But today is March 11th. So in less than a month, this trial will begin. They said, they said earlier in this stream, in this hearing, that the jury selection will start on March 31st and will probably take a few days. So the judge said he figures that opening statements should start around April 7th ish, give or take a couple of days here or there. So I'm excited. I can't wait. I don't know. I love these pro se cases, and I love that she's gonna do this. I love that she's gonna do this, not for her benefit. I could. They need to put her under that jail, and you know, I could say some really mean things right now, but I think that they should be able to put her under that jail and the other part, half of her. I'll say that. Put half of her under that jail and the other half of her under the other jail where she was found guilty of murder of her 2 kids. So, you know. Mm, 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 mm. Right, Lauren, it's so sad that he's got to go through this all over again. Yeah. Yep. Well, I'm glad that you guys all put ones in the chat wanting to do a little bit of a refresher on the situation with Charles Vallow and Brandon Boudreaux and Alex. I need to get my ducks in a row to do that, to get that started, because that probably would take a few days. And I would love to do that. I'm going to check out that trial that Ween Baby was talking about. Ween Baby, what did you say that dude's name was? Jordan something. Jordan. I got to write it down. Jordan. Oh, I can't remember what you said the last name was. But she said that trial starts today, and the judge is a little bit of a firecracker, apparently. Ween Baby, are you still here? She was here 3 minutes ago. I think I'm going to go change my clothes, get me some tennis shoes on, and go for a walk. That's what I'm going to do. That's what I'm going to do today. It's beautiful outside. But we will be back tomorrow. Okay, Ween Baby, what was the name of that dude that you were talking about that was on trial pro se? And the judge was a firecracker. What'd you say his name was? Jordan something. Mm-hmm. Oh, it was something Jordan. Okay, I'll find it. Pro se. Was it on like one of the big ones like Law and Crime or Court TV, or was it on like some local station? A weird first name. Yeah, Margaret, you ain't sending me no rain, ma'am. I don't want none. Osprey or something. Osprey. Oh, okay. Recovery Addict is streaming it. Okay. Oh, wait. okay, I did see Recovery Addict had something on earlier today, and he totally, like, I was like, you tricked me, buddy. Because I thought that he was playing Minecraft because he says something about a Minecraft trial pro se something in the title. And I was like, Mike, what is he doing? Is he like playing some kind of game? And I clicked over and it was a legit trial, but he called it Minecraft because the way the camera people have the like gallery or the jury like pixeled out. Funny. I love Recovery Addict. All right. I saw that. That was funny, Wee Baby. But he totally got me. I was like, what is he doing? And I clicked over and I was like, you little turkey. All right. All right, you guys, I'm going to scooch on out of here. Like I said, I think I'm going to go for a walk or at least get outside for a little bit. And I will see you guys back tomorrow. I'll check out that trial and see, Ween Baby, what it is that's going on with it. Otherwise, we might start. I don't know. I need to make a poll. I need to make a poll. Because if today's the 11th, we've got like a month-ish before this trial starts. The Vallow Lori stupid doo-doo head trial. And I would prefer to do the Charles Vallow like refresher course closer to Wee Baby, do you know how I tried that. Do you know how impossible it is to make a schedule? Because you put things on the schedule and then that hearing is canceled or it's delayed or oh, well, we found out they won't allow cameras in the courtroom. And I tried. It's impossible. Drives me crazy. I would love to have a schedule. You know? I would love to do that. But, they make it impossible to do that. Because everything's so wishy-washy. Wishy-washy. I mean, the only thing I could do is, because what I did before was put like big trials that I knew we wanted to watch on a calendar and then would try to fill in the gaps with just random update, random stuff like, hearings and all that kind of stuff. And then have other filler stuff like the deep dive kind of things, but it just changes so much. It changes so much. So eventually I gave up. It's good to see you again, Lauren. I'm glad you were able to hang out with us today. I loved it. It was a nice surprise to see you in here today. We certainly missed you too, ma'am. All right, you guys, I'm going to go ahead and scooch, but I'll see you back tomorrow. All right, make sure to hit the thumbs up before you skedaddle. Make sure to subscribe if you're new here. Would love for you to hang around. Click that notification bell. And if you're watching this later on, make sure to put a hashtag replay in the comments down below and let me know that you were here and what were your thoughts on Miss Lori Vallow and her cute little off-the-shoulder top and her cute little wedding ring. and all the things. All right. I love you guys, and I'll see you back tomorrow. Bye.